Thank you, Dr. Gadar, and very good afternoon to all of you. Very quick introduction about myself. My name is Ravi Bhola. I represent the intellectual property law firm in India by the name K&S Partners. In terms of my technology background, I'm a biotechnologist. After completing my education, I worked with Sharing Plough for 2 years' time, assisting them in their multi-centric trials in India for interferons and antibodies. And then I joined my present firm sometime in 2001. I've been part of the firm at their Gurgaon office for first 4 years, and then I relocated to Bangalore to start Bangalore office of the firm. In terms of my presentation today, I'm going to talk about 3 different cases and going to link them to the way we draft our specifications. Since we don't have anybody from US on the panel, I have taken the liberty to put Marriott case in my presentation. So let's look at the Marriott case to start with. As some of you probably already know, that Marriott is a company which had got several patents, US patents, on 2 genes and their fragments and method of diagnostics and cDNA technologies or cDNA products. Essentially, their invention was that they were the first one to identify the location of these 2 genes in the humans, and they were the first one to assign a functionality to these genes. And the functionality was that the moment you have any mutation in these 2 genes, it can increase the chances of breast cancer and the ovarian cancer in the subject. With these inventions, they got a few patents in US, and the issue came up in the Supreme Court in US as to whether the human genes and the fragments and the cDNA are patentable subject matter in US under 35 USC 101 or not. The contentions, the plaintiff here, which had filed a declaratory suit in US, AMP, Association for Medical Practitioners, their contention in this case was that, look, DNA or the genes are naturally occurring sequences. They are there in nature. If you look at even cDNA, it is essentially dictated by nature. And therefore, there should not be a patent for the same when you look at 35 USC 101, because there is no new product formation here. On the other hand, when you look at the contentions which were put forth by Marriott in this case, Marriott said, look at the practice that we had at USPTO for past several years. Lots and lots of patents have been granted on human genes in US, hence our patent and the claims are indeed valid. They also said that there is indeed a new product formation in our invention because I have severed the covalent bonds in this entire genome to get to these genes, and the moment I sever these bonds, a new product creation happens, and hence, therefore, it doesn't fall under the scope of rejection. Further, it went on to say that the research work that they have done required a lot of effort, and therefore, it's not easy to identify the relevant genes and assign a functionality to those genes. In view of the same, Marriott claimed that their patents are indeed valid. Let's look at what the court said in this case. The Supreme Court of US said, look, these genes, these 2 genes, and the corresponding the fragments that you have coming out of these genes do not meet the requirement of patent eligibility in US under 35 USC 101. You have not really created any new product. Though you may say that you have severed these bonds and therefore there's a new product formation, but if you look at the specification that you have drafted, all through the specification you have talked about discovering a gene, isolating a gene, trying to look for this particular biological sequence and things like that. You never presented your specification to say, here is a product formation, here is the creation of a new product. Hence, under 101, it's not a patentable subject matter. However, the Supreme Court said that as regards complementary DNA, cDNA, there is indeed a creation of a new product because cDNA in its that very form doesn't exist in nature, and hence cDNA is indeed patentable and you will have the valid claims on cDNA, but as regards gene per se and the fragments coming out of those genes, those are found to be invalid. Here I must also add on that the methodology claims, that is method of diagnosis, that is using these genes to identify whether a person runs the risk of developing breast cancer or ovarian cancer or not, was not the subject matter under discussion in this case law. Now, looking at this case law and in terms of the practice, clearly, a lot of practitioners like us who file lots of patent applications in US, we are in a bit of a dilemma here because a lot of cases where we have granted patents with human genes, those are adversely affected by way of this